back in the day, it was, you had I would call it the wedding cake, it was the tiered, the waterfall, the double dip. And that's all being sort of flattened out these days. You never see that anymore. You don't see the double dip. Everybody's doing the 1x non-participating. I heard in the Valley a while ago that they've stopped even doing that. People are saying, we'll just take ordinary shares, assuming the next guy also takes ordinary shares. Because if he gets preferred, then I'll have what he's having. But if he's willing to take ordinary, then we'll just all take ordinary.
Welcome to 20-Minute Leaders. Just sit back, relax, and learn from the leaders of today. It's a journey. Each one is different, unique, inspiring. Let's get started. This episode is powered by J Ventures, a community-driven VC fund in Silicon Valley in partnership with Leumitech, sponsored by Homeward Ventures, Hippo Insurance, Upwest Labs, Synergy Global, Hillel at Stanford, Leap, Birthright Excel, Serona Partners, and in media partnership with CTech. Welcome to 20-Minute Leaders, and today we're in the legal sector, but in tech. Meet Inbal Perlstein-Mandelbaum, senior partner in Cohen. Inbal's practices focuses on high-tech, venture capital, corporate, and commercial laws. Inbal advises companies in all phases of growth, from early stages through M&A, on all corporate and commercial aspects. Inbal Perlstein-Mandelbaum, thank you for joining me, 20-Minute Leaders. How are you today?
I'm fine, thank you. Very excited to be here. Thanks for having me.
I'm looking forward to chatting with you about both your position as senior partner at Cohen, but also the way that you're interacting with startups and especially companies in venture capital in the growth stages and emerging stages. You're working with a lot of companies to work on these pivotal moments in their life cycle that push them forward. You're also working with some amazing accelerators in the foundation of the 8200 Entrepreneurship Unit, and you're working a lot in all these different verticals. And oftentimes I get to talk to founders and investors on the way they perceive things, and here I get to talk to somebody who's also behind the scenes a little more, but really seeing the bits and pieces. So thank you very much for joining me.
It's a pleasure.
Thank you.
So I've started working in this industry roughly 18 years ago. I think what drew me to this particular aspect of law, as opposed to being a litigator or any other type of law, is that unlike other legal terrains where it's a sort of win-lose situation or zero-sum game, this particular vertical is not so. So at the end of the day, whatever we're negotiating or whatever we're doing, 5 minutes later, once we're done negotiations and and the ink is drying on the paperwork, people join forces and work together and take it to the next level to build a company. So that's what initially drew me to this aspect of the profession. I was also very good at math, you have to be somewhat unafraid of numbers and technology, at large, to be able to do this position well, in my view. And so, initially I was drawn to, and it's the startup, nation and hype. And I started working 18 years ago with this industry. And what I find most fulfilling in my job is, other than working with brilliant people on, bringing the next level of technology, whether it's the cybersecurity or digital tech or, medical health products, is that you really get to experience their growth. And, I usually start working with founders at a very, very early stage, what you would call day one, but actually it's even prior to that. So, prior to company registration, they're still putting together the team. You still see people, coming in and out. This is also something that is more frequently seen over the past years. I mean, if maybe 10 years ago, the founding team would really stick together for at least a good couple of months. I know if it's millennials or whatever, but, you see more, you see people, the team changes quite a lot, even, up until the first, seed or pre-seed or whatever it's now named, financing. And then you get to experience, working with these people through their life cycle, from the pre-seed to seed and then on to the series A and B. And, in the past year, I've experienced working on two M&A transactions, quite large and public, and this is with clients that I've been working with for the past 8 years. So
Wow.
it's very it's very fulfilling, and you watch them grow. And there's a lot of tutorial that is done, on my end, because initially a founder may be brilliant at what they do, but they don't know, what dilution means, or
Right.
how a finder fee agreement should be constructed, or what is a safe. And so there's really a lot of, I would not say mentoring per se, but explaining, and I think that's a big part of my job is, to first, get the founders and the companies sort of up to speed on what is common, what is standard, what they should be looking out for, what's important, what's not as important, what's a deal breaker, what's not. And that's a part of my job that I actually enjoy a lot. And I think that's something that also changes as time goes by. So, a founder that we're working now on their B round or their C round, they're a different place than they were, 3 years ago or 2 years, depending how quickly they evolve, when we were just setting up the company and putting together a founder agreement and, every purchase concept was all new to them. So that's what I find most interesting in the work cycle.
Incredible. Now, if we're looking at this position in which you're working with the founders, especially in the early stages, and you're mentioning that there are a lot of these, complex ideas that you really have to wrap your mind across, and there's so many different combinations of things that can happen as we're structuring deals. What do you see is most helpful for founders as they approach these different negotiations? As even in the most common things like dilution and those types of ideas. What do founders do in the early stages to really get acquainted with it? And at what stage should they do it? Should it be really early on? Should it be as we get closer to the end of the negotiations?
So, one of the most, helpful tools is, if we're talking about dilution, for example, is to see a pro forma cap. Now, a pro forma cap is an Excel sheet and it rolls out, the entire pre-closing, post-closing, option increase. Many times I see founders coming, in with, a term sheet proposal, but not even just a term sheet proposal, just, like the email with the 3 lines of, we'll put in whatever, 5 million at pre-10 or whatever, or 4 at pre-12, whatever that might be. The whole pre-post closing valuation is a concept that people, it's a mathematical concept that people need to understand. If somebody's investing, for instance, 4 million at a pre-money of 12, he's getting, 1/4 of the company. Because eventually the post would be 16, which is the initial 12 plus the 4. I mean, it's very technical and it's very, mathy. So I really try and, spell it out for them, show them what it would actually mean, the actual cap table, what would it look like? And that's a working tool that's, essential. But also I try and, I think the advantage that I have today is that I've seen these things sort of come to close. I've seen the cycle go through many times. And so I can, many times I can say, roughly speaking, clearly not on the 10th of the percentage, but I can tell you where things are going to end up eventually, whether it's in the negotiation or in this round or the next round, and sort of give them a grasp of what it will eventually look like. And this is just based on experience. Just the other day, I had a founder call me. He wanted to restructure the whole company. He had many early on investors. They weren't contributing. There's maybe a down round. There was a whole discussion, and I didn't have their cap table in front of me. But I told him, listen, from the sound of it, this is the cut the investors are going to want, and there are no investors at the table yet. This is the ESOP increase they'll want. The founders will get a juice up. Technically speaking, in 2 rounds, this is no longer an issue. So don't waste your time in, legal fees on, fixing something that's eventually mute. And I think that, sort of that whole, understanding, what is ahead of us and what is, the probable scenarios that we're going to foresee, if you're looking at capitalization, is, it gives you some comfort, and and you're able to say, it's going to end up this way. The last 50 times I've seen this is where it ended up. So we can brainstorm on this, we can insist on that, but it's eventually probably going to go in this direction or another. And then it's either a non-concern or it's something that we can, address now if it's something that we're, concerned with, certain anti-dilution protection,
Right.
for instance, in such a case. But I think having that
So I have a question
holistic view.
So exactly in that regard, and given the holistic view that you're presenting here, and understanding the context and the perspective of everything that's happening, how do we know as founders what we should be really focusing on at any given deal, right? So there's so many different factors and so many different things that we may be thinking about as we approach these deals, and then we have to also know, what are we willing to fight about, and what can we compromise on? Is it simply, asking you and saying, Inbal, like what should we do and what should we be concerned with? Or are there already patterns that you've seen that I know already when I go raise my seed round, these are the red lines for me, and these are the things that I shouldn't really, think too much about?
So yeah, I think good legal counsel, especially in these very early stages, is keeping the client focused on what really matters, and where are the red lines, where we shouldn't budge and where we shouldn't, I don't like to say it's a no-go, but, there may be items that are no-go-ish, okay? So, I mean, if you, desperately need the funding, then, clearly you have less of a leverage. But that's just, so it is about understanding from a trusted counsel, what are the things that you should be most concerned with, and what, sort of, would eventually wrap up in a certain way. But it's also explaining that I usually represent companies and founders. So I don't usually represent funds. I sometimes represent funds, but normally, for the most part, I represent companies. But this is also, going back to counsel for the funds and sort of, having that discussion openly with them. So whatever they're asking now, as a seed or pre-seed investor, will later come to haunt them, because
Right.
Later investor will ask for anything less. This will be the starting point for any future negotiation.
Right. This
At a
precedent.
point in time where they're going to be in an interest alignment with the founders, probably more than they are with the new investors. So, for example, a C round investor investing whatever 40 million, 70 million, 100 million dollars at a company valuation of 400 or 600, it has much less in common with the pre-seed investor who invested 2 at 5. Then, so at that point, the seed investor or pre-seed and the founders are much more aligned in interest than those investors may be amongst themselves. So I think the holistic, business-oriented approach of, let's all be grown-ups and work together and, make this, sustainable, which I try and implement, is, it goes around. So, whatever we're doing now will be, duplicated over and over and over, until an M&A. And having that perspective in mind, not just for us as founders, but also, when speaking with our investors and making sure, we all see that is a part of my, is a part of my job, and it's a part of protecting everybody's interests. I mean, it always has to make sense. And one of the ways you see is also with, back in the day, it was, you had I would call it the wedding cake, it was the tiered, the waterfall, the double dip. And that's all being sort of flattened out these days. You never see that anymore. You don't see the double dip. Everybody's doing the 1x non-participating. I heard in the Valley a while ago that they've stopped even doing that. People are saying, we'll just take ordinary shares, assuming the next guy also takes ordinary shares. Because if he gets preferred, then I'll have what he's having. But if he's willing to take ordinary, then we'll just all take ordinary. If the company's doing well, that's probably for everybody's benefit. But it is, an understanding of, it's a more mature understanding, but, that's where we strive to be.
Right. Now, what is really the role of you, as a legal counsel and as a partner from the legal side for companies, as you go through the deals, are you really involved with also the negotiation piece, or is it mainly, executing a negotiation that was done between the founders and investors? In other words, where do you fit into this whole prisma of the deal that's forming here?
So usually we would have. So usually the amount invested and the pre-money valuation would be the two factors that would be agreed between the company and the investors. So, sometimes they may also agree on the format. I mean, whether it's a SAFE or, as an interim financing vehicle or full-blown equity investment. And then everything else is what I'm negotiating. And it comes, and it's from the very, big items in my view, which is the ESOP reserve pool, which can be significant on percentages, because if you're setting aside 10% or 20%, that's 10% of the company you just gave away without saying you did so, in valuation or in amount raised. So that's one aspect, but also protective provisions, which are veto rights, very important, especially in early stage rounds. Other preference rights that the preferreds may want, whether it's over allotment on next financing, which I think is a crucial point, because you don't want to block yourself from being able to get more funding from other, parties that are not around the table currently, or from strategic investors. It can be, special provisions if, somebody's asking for a warrant or a double dip. So really, it's not just execution, but it really is, everything normally other than the price or the, and the investment amount. And I can also tell you that sometimes, I've had an experience where the company has agreed to a certain safe, structure and amount with a certain investor. And, it was one of those Y Combinator post-money safes that, they're very, they look like vanilla, but they're very actually complex, because if you have additional safes coming in afterwards, you're really just diluting the founders, aggressively, and it's a tweak people don't necessarily understand. And I sort of ran the math with the founders, and I told them, listen, the way this is structured, like the best case scenario is what we would actually have if we just do, a round right now at this valuation, because this could not get any better for us. This could just get worse. And then we shifted it, and then we took it from a safe format to just an equity investment, which turned out to be a very wise decision, because they didn't meet their, next equity goal, in the time frame that they had thought, and then they did need an additional safe amount, and they would have really been hurt had they gone, that post-money safe way, and not just, a regular equity round where everybody's in the same boat and diluted, by whatever comes next. So, yeah, we do the entire negotiation and thought process, and many times explaining. Even founders, if it's their first investment round, they'll definitely know, what a cap table looks like, because most of them are pretty mathy, but they won't understand what a double dip is. What's liquidation preference, what the veto rights mean. The board composition is something we would normally think about together, and what works, what makes sense, what doesn't look too bad. You can't have a company with 7 board members. With a company of 3 people, it just looks weird. So just really every aspect of it.
So what it sounds to me is that there's this huge puzzle. There's so many different possibilities and so many different combinations of things that you can do here. And it sounds that one of the most amazing, parts of it is that you get to build this whole foundation again and again with different companies. Now, how much do you have to understand really the product of what they're building, and really understanding, either their technology or their differentiation or their go-to-market when it comes to these things? In other words, how aligned do you have to be in order to be a good partner of theirs throughout this negotiation journey and deal structuring? How much do you have to be aligned on the actual company level and the vision of the company?
So to be frank, I think when you're doing just finance rounds, you don't need more than a general understanding. You need it for mostly the reps and warranties. You need to know where the exposures might be, where the company may be taking risks that you would need to disclose. But myself personally, I don't only do transactions, so I also do license work. So for so companies, I represent them in finance rounds, but then I can also represent them, in a SaaS agreement, like a huge enterprise license agreement. So then I actually need to understand their product. I don't need to understand it, to the core of it. I don't need to understand how the code works, but I need to know if it's on-prem, if it's a SaaS solution, who's accessing, what are we giving them? What are the actual deliverables? Sometimes it's a report, sometimes it's a recommendation, sometimes it's, a dashboard. So, yes, the more I understand and the better I'm familiar with what exactly they're doing, the more I can be helpful in putting together a contract that is, protective of their concerns and understanding. And this is also interesting because recently we've had a lot, AI. Everybody's talking about AI, so that's the buzzword now. And I've just recently changed definition for permitted uses. In many of the contracts that I write, to include just like a general license that every client or customer of my customers' software gives my customers to enable the software, to progress itself and to develop itself. So this is just like, I don't want anybody suing us, 2 years down the road. Hey, your AI algorithm used my data, pictures, whatever, to improve the software. And now you're selling that, new enhanced and improved software to somebody else. These are things that you learn. The more I understand, the more I learn, about what they're doing, and the better, the legal protection and sort of creativity can be, to an extent.
Amazing. Inbal really just sounds like a really amazing job, and just a really fun position to be in, where you're, on one hand, it sounds like you're right at that sweet spot of helping founders deal with things that they may not have they're not, obviously not domain experts in this, at least most of them are not. And you get to fill in the shoes of a really critical moment in their life cycle, where they are about to grow and they need to do it in a really good way. And you're helping them build a foundation to continue having, the right growth with the right partners under the right deal, so that the company can continue to succeed for many years and not get stopped some way down the line because of something they did 5 years ago that they didn't really realize. And so it sounds like both it's a really important job for the startups, but also it sounds like it's a really fun one for you. Both the puzzle piece, the math piece, and it sounds obviously, with licensing and the way that you're interacting with the technology and understanding how SaaS works and how these companies are built, you provide a lot of value there. I really want to thank you for taking the time to join me. I know how busy you are, and I'll let you go back to helping the many startups that you work with. So thank you very, very much, and stay safe and stay healthy.
This was a pleasure.
Thank you very much.
Thank you. Stay healthy. Bye.
Bye-bye.